Buenos días.
Good morning. Good morning, colleagues. Dear members of the delegation of Cambodia, observers, members of non-governmental organizations, we are going to start the meeting number 3139 of the Human Rights Committee, and we are reviewing the second periodic review of Cambodia. We had to finish the dialogue yesterday at the point at which they were going to start the interventions for the follow-up questions from the committee. For the first part of the list of questions. So we're now going to continue with that process. I have some colleagues who would like to take the floor. And the first speaker on my list is Mr. Benashaw. Mr. Benashaw, you have the floor. Thank you. Thank you very much, Chair. I have to admit that I was a little bit surprised yesterday by the reaction of the Honourable Head of Delegation, Mr. Sombat. First of all, I wanted to say that the role of the committee is not at all to censure states, but rather to assist them. And that's the exercise that we're trying to undertake now. It's an exercise of dialogue, constructive dialogue. So that's how you have to take it. You have to understand that the aim of the committee is not at all to, how can I put it, to pass judgment. We're not a court, but rather our task is to assist you so that the human rights situation can be better in all the countries that we consider. Now, the chair of the committee, our colleague, Mr. Salvioli, responded to you yesterday with regard to the document, so I won't go back to that issue. You asked us where the information came from, who we have that information from, and the response was given to you by the chair of the committee. We only work on official information here that is public, that's published before the beginning of the session, and that all delegations have access to. This exists on the site of the High Commissioner of Human Rights. And all the documents that we use are public documents. Now, of course, we do not take what the NGOs as given. We undertake our own observations, and we allow the representatives of the states to respond to these allegations. And that is the exercise. We have never taken the information that is given to us as read, as completely unassailable. We always examine them, and then it is up to you to respond to that. So that's just to respond to that fundamental question. You shouldn't believe that we use rumors, if you like, or reports given to us by NGOs, and whether they be national or international, as definitive information, but rather as information that we introduce into this discussion in order to allow the delegation to respond. And specifically yesterday, while the head of the delegation was speaking, I'm sorry to speak so openly, but he gave me the impression that he wasn't up to date with the activity of non-governmental organizations within the country itself. And you said that as the Human Rights Committee, visits were undertaken to prisons, and that's all well and good, and that you were carrying out investigations into the human rights situation. But I think that the initial effort that an organization such as the one that you lead is to contact NGOs, and NGOs who have contacted us and who provided us with information Well, if you had contacted them, you would have been able to communicate that information, and that would have allowed you to have a more generalized and indeed more in-depth idea of the situation in your country. So now to conclude, just very briefly, I'd like also to say to you once again, very honestly, within the context of this constructive dialogue, that many questions that we raised didn't have any responses to them. And the questions that I personally asked, and that had to do with the most important rights and human rights, that's the right to life, didn't really get a response, independently from the fact that there have been extrajudicial executions or killings. Now, the problem that really should concern your government is impunity. And that's impunity in the light of serious violations of human rights, most notably the right to life. It would seem that sentencing and prosecution of those responsible before the courts has not been followed up thoroughly, and that hundreds of executions have not been investigated. These are hundreds of executions that have been under the responsibility of the gendarmerie, the army, or the police, as has been reported by a number of NGOs. These have not been followed up or investigated, and that means that the security forces give the impression of falling on one side of politics, if you like, and that means that they sometimes aren't followed up, they're not investigated, they're not prosecuted, they're not sentenced, and so the problem of impunity for us really remains a very serious problem. So that's what I wanted to say, Chairman, and I would ask the delegation to take everything that we say to them into account and to look at it in a positive light. It's out of sympathy for Cambodia that we say it. We're not seeking to punish or to censure you. Rather, personally, for my part, I can say to you that I have high admiration for your country, for its history, and for its place in history. And I have read a great deal about the Khmer Empire, and I have to say that Cambodia really lives up to its historic reputation. So thank you.
Merci beaucoup.
Thank you very much, Mr. Benachou. The next speaker on my list is Mr. Victor Rodriguez Recia. Mr. Rodriguez Recia, you have the floor. Very good morning to everybody. In opening up this dialogue again, I would just like to ask some questions, some follow-up questions, first of all. And then following on from the line that my colleague followed, Mr. Benachou, with regard to this constructive dialogue, what we started yesterday and that we're going to finish today. Well, we seek only to be constructive with a human rights approach. So I'm not going to reiterate what we talked about with regard to the sources, but with regard to what I was saying about the penitentiary system and an invitation that made to the state to visit these prisons. I participated. That's the only one I'm aware of in Cambodia, unfortunately. I know that it's a country, that's the only visit I've made, but I know it's a beautiful country. But what I said yesterday was based on what I had noted, what was in documents that are made public. And perhaps I wasn't aware of a few details, but as a source, I can quote the same response that the state gave in writing to previous questions, and this has to do with mental health. Now, the state says that as part of its mental health practices, the penitentiary regime gives half an hour to prisoners so that they can have some fresh air. So that means 23 and a half hours of being locked up, and that's what's given to people in detention. So that's not real mental health, I don't think. I think that the justification that was given to us by the state, that this is because of an issue of security, Well, all the prisons in the world have that same security risk, I think, but that security should be guaranteed without prejudice to the integrity of individuals deprived of liberty. They have the right to exercise their right to open air, to space, and that should be more than half an hour. So, yesterday we also observed that the state was saying, or rather was denying the fact that there is torture. Now, with regard to this and the situation in prisons within the penitentiary system, we have observed cruel, inhuman and degrading treatment. But we have also observed that this treatment can have a cumulative effect, as international legislation says to us, and also as is noted in other bodies. And this accumulated treatment can amount to torture. So it's with this in mind that we talk about problems of health provision, also health problems, tuberculosis, and the issue of half an hour of fresh air. So we'd like to draw attention to that we have noted this situation within this committee, and that we need to take note of that in order to try to correct it. So that's what we're trying to do, to bring this up to date so that it can be corrected and therefore to improve prison conditions. So this brings us back to the issue of monitoring, because we were talking about the existence of a national prevention mechanism for the prevention of torture, and also a project, or indeed the aim to create another mechanism. So the mechanism that the mission was discussing yesterday is an interministerial mission or mechanism. So therefore it doesn't comply with the OPCAT's requirements, as was highlighted by our colleague Bata yesterday. And also I was at a workshop which took place in Cambodia to create this mechanism. I think it was 4 years ago, and I can see that we're still waiting for another workshop to take place. So we'd like to encourage the state to really recommend that this go forward, and so that this mechanism move forward. We'd like to really ensure that there be a driving force to encourage this. But I wanted to ask the state, because I have contradictory information here. Today, could the Office of the High Commissioner visit prisons and other detention centres? Could today the Red Cross do so? Could the civil society organisations have permission to visit these prisons in order to carry out monitoring? Because the data that we have, the information that we have, that we've examined, makes it seem that we don't have access of extended monitoring to these locations by civil society organisations and other bodies. So I'd just like you to alleviate my doubt in that respect. Now, another issue is one that many of those deprived of liberty are put in prison because of drug taking. So how is this being dealt with regard to the issue of and minimal consumption of drugs? Because many of those who are awaiting trial are doing so because of that crime. Now, to conclude, I didn't receive a response to the question with regard to the death of Mr. Fair in November 2014 during the water festival. What is being done in order to investigate this case? What findings have been made? And finally, with regard to the statistics of torture, I think that there is information about cases of torture, information that has been brought to us by the Office of the Ombudsman and the High Commission of Human Rights. There have been reports and complaints that have made. So we would like to know, what is the fate of these individuals? What effect has this information had on the ministry in order to investigate these, and especially to combat impunity, especially with regard to reports of cruel, inhuman and degrading treatment? Thank you.
Muchísimas gracias.
Thank you very much, Mr. Rodriguez-Recia. I would now like to give the floor to the Honourable Delegation of Cambodia so that they can respond to these questions and also to finish giving us the information that they were giving us yesterday afternoon. Your Excellency, you have the floor.
Thank you, Mr. President. As yesterday we closed at 6 p.m., and then I supposed to have time to respond to the general comment, and also to some question posed by our distinguished committee member. So today, I wish to respond in two parts. First is responding to the general comment, and second part is to a particular question posed. Like this morning, our distinguished member of the committee mentioned that we did not respond to some question, but to me, I think did not respond to some question is not I may say it's not a proper word to use, but we can use not yet response. Because as you all know, we finish at 6, exactly according to the time fixed by the meeting. So we do not have enough time. Even myself, I do not have time to respond. Okay. And then now my first part, I wish to respond to the general comment. So I wish to inform Excellency, ladies and gentlemen here about the situation of human rights in Cambodia. In addition to what our head of delegation and our delegation, as already mentioned yesterday, in Cambodia we have like 1,000 NGOs working in human rights issues. And some observers say that Cambodia is like a kingdom of NGOs. In addition, we have foreign newspaper owned by the foreigner publishing in foreign language, criticize government freely. We have radios, foreign radios broadcasting in Khmer, criticize government freely. So this is showing that how strong commitment of the Cambodian government toward promotion and protection of human rights. And also, since 1993, we have accepted the office of UNOHCHR in Cambodia. And also at the same time, since 1993, we have country special rapporteurs. So far, we have already 5 country special rapporteurs. And now we are in the process to identifying the new special rapporteur in succeeding the current special rapporteur. And the result will be announced during the Human Rights Council meeting at the end of this month on the 27th. And then now I turn to a particular question, question from number 1 to number 14. First, regarding to the extraordinary chamber in the Court of Cambodia. The question posed that whether the government will take experience lesson learned from that ECCC to be practiced in the court system of Cambodia. Yes, of course, we will use. As you already know, the government have contributed in kind and in financial means to the national component. And then we show our political will and strong commitment to end the impunity and to bring the leader of the regime to be accountable for their act. So this is the question regarding to the ECCC. And regarding to the LGBT, of course, in Cambodia, so far we does not have yet that law, but we do not have policy against that group of LGBT. So if some case like one or two people or a small number of people, the issues happen. It happens all over the world, but we cannot generalize it as a policy of the government. Regarding the enforced disappearance, as I mentioned yesterday, Cambodia already ratified the convention against the enforced disappearance, and we regularly respond to the Committee of Enforced Disappearance. And I take example like the case of Mr. Kamsupat, the 16-year-old young man that the committee mentioned that has disappeared on the 3rd January 2014. This case, the government and the competent authority have worked tirelessly to bring the light, to bring the issues into the light. And also we work and coordinate like through the mission here in Geneva, my mission here in Geneva. As I said, we respond, we coordinate, we cooperate with the committee. We never ignore it. And we are members, so we know our obligation, our duty, how to be a member, a good member of this convention. And regarding the special procedure mandate holder, our distinguished member of the committee mentioned that since 2012, the thematic special reporter on the human rights defender request to visit Cambodia, and we did not respond. I wish to inform the committee that so far, as I said, we have already 5 country special reporters. Those 5 country special reporters never ever get rejected by the government when they ask to visit Cambodia to exert their mandate. And furthermore, we cooperate and we give all assistance, and all the authority concerned in Cambodia work and dialogue with those special reporters, country special reporter. For the thematic special reporter, last year, the special reporter on the freedom of association and of a peaceful assembly visit Cambodia many times. And as we mentioned clearly last year during Cambodian second cycle of the UPR, we said that we will never reject the country special reporter demand or thematic special reporter demand to visit Cambodia, but we do not extend we call a standing invitation. So the thematic special reporter on the human rights defender is not an exceptional case. Like a special reporter on human rights defender, how can he visit Cambodia like many times last year? So this is my answer toward the special reporter. And then regarding the budget allocation toward the people with mental disability, our distinguished member mentioned that the percentage of the budget allocation is very, very, very small. So it is an old issue, as we all know, since the inception of this convention on civil and political rights. How can we balance fairly between civil political rights and economic, social, and cultural rights? Since 1966 until 1976, it took 10 years, a decade, for this convention to ratify, to put into practice. And then for Cambodia, like we are listed in a LDC, least developed country, we have budget constraint. So how can we allocate fairly and satisfy all the players within the framework of very limited budget for the government. Of course, the government, the mental disability person is one of the government priority. But we also have to think about civil political rights and economic rights. And regarding the comment on the female or gender representation in our delegation to come here, yes, among the 7, not today we have 8 delegations, we have 1 female. You may say it's not a gender balance, but let me respond back. Since 1993, as I said, we have 5 country special reporters. Justice Michael Kirby is a man. Mr. Thomas Hammerberg is a man. Mr. Peter Lebrecht is a man. Mr. Jasgai is a man. Now current special reporter, Professor Subedi is a man. How is the gender balance? Okay, one thing. The other thing, from my understanding, since 1945, the UN, the inception of the UN, how many Secretary General of the UN is a woman? From my understanding, is no. No Secretary General of the UN is a woman. And then, last but not least, regarding the question of the right to vote of mental defectiveness of people with mental defectiveness. And then, according to our distinguished member of the committee, refer to paragraph 230 of our national report. So I request, or I urge gentlemen to read the paragraph 230 in full, not just first part of the paragraph, or maybe that the committee interpret the paragraph into that way that the Cambodian government have some discriminate against the people with mental disability in terms of right to vote, or maybe because of our English language expressed in written is not clear enough. So we do not mean according to the distinguished member mentions. The first part of the paragraph 230, we mentioned that, okay, all people above 18 years old have the right to vote, except people, the prisoner, people with mental defectiveness, or under guardianship by the letter from the competent ministry or institution. It means like that. It means like that. If the people with a mental disability get the certification, duly certification from the competent ministry, it means from the Ministry of Health, or from the incompetent institution, it means from the clinic, medical clinic, from the hospital. So it duly certified. If one people with mental disability is not fit enough mentally, so how can they vote? I take example the case of the ECCC, Extraordinary Chamber in the Court of Cambodia. Take the case 002. There are 4 accused, but one accused declared by the court mentally is not fit enough to stand trial. So she got freedom right now. But before she got the freedom, because there is a duly certified by the competent institution, it means by the hospital that she is not fit enough. So it applied the same to the other mental disability that have duly certified certificate from the competent authority. So the government have no discrimination toward the people with disability. So if you want to be clear, you should read the 230 and 231 together in whole, because it linked together. It will reflect that the government do not have policy discrimination against the people with mental disability. I thank you.
As you, Mr. Chairperson and members of the committee, and all participants here today, this is my additional information. I want to, in regard to gender, the government took it into consideration. Gender, the Prime Minister has said in the fifth mandate, in the state institutions, leadership roles, Secretary of State level, at least there's one woman. Under Secretary of State, there must be a number of, we start from 2013, this mechanism. Especially at the local level, local authorities, like governors downwards, we will have deputy governor and deputy police commissioners or one woman, and also deputy governor of the district levels. We arrange to have one woman at least as deputy. Recently, in the village, each village, if there are 3 members of the village, there must be one woman as a member in the village. So up to now, gender in the leadership roles, we have 20% of women in the leadership roles of the public institutions. This is the goodwill of the government of Cambodia. And Ministry of Women Affairs, they are working on this process to insert women as in the leadership roles. They are mainstreaming females, mainstreaming gender equity. We have to look at their capacity as well. As you mentioned that Cambodia woman, the history, you know that the history of Cambodia. So our females, they only take care of the family and looking after the children and looking after the households. But now the government promote women. So we start to promote, and we believe, for sure, we believe that in the next mandate, 1 and 2, then we will have more and more women participation in the leadership roles in the public administration. This is the vision of the government of Cambodia. Recently, I would like to give the floor to His Excellency Polum. He will, in the first question, Mr. Panaso, that regarding freedom of expression and other issues. Reports by the OHCHR, Just Public, we and OHCHR are not separated. We work together. We have cooperation. Each year, OHCHR issue their own report, and we also work together to examine the report as well. What are the implementation, and we read together, we discuss together, And we also make a statement. Uh, One is OHCHR and one is a government report. And these reports we are not hiding. We broadcast, we disseminate the report so that especially the Cambodian peoples, they can read the reports and they understand the situation of human rights implementation in Cambodia. Whether it is what is the report of OHCHR, what is the report of the government, what is the difference. So this is up to our people to make the judgment. Uh, 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 if you evaluate that Cambodia is like that, so in the next mandate, Cambodian government will not be elected again, something like that. So we are working hard based on this principle, especially right to life, on CCPO. ICCPO, I want to inform you that if Cambodia is so dark like that, probably no one can start political parties in Cambodia. You can see in the election, during the election campaign in 2013, the way they campaign, you can compare to your countries, whether this campaign something like racial discrimination technique, it cannot be one country be a chaotic country, use the space for violence, riot or something like that. Any government would not allow that to happen. So it's importantly national security and social order for the people to live in peaceful and for the national developments. I would like to give the floor to His Excellency Pollam, please. Thank you very much, Mr. Chairperson and ladies and gentlemen who are here. First, I appreciate and applaud your consideration, especially the questions imposed, and we will have dialogues this morning further to clear out the doubts, any doubts. And I agree with Mr. Ambassador, Cambodian Ambassador, who raised the issue in Cambodia. We have association and NGOs, and NGOs. We have more than so much NGOs and associations. I want to inform you that my name, myself, Mr. Pollam, I am in charge of NGOs and CSOs. Up to now, we have more than 4,300 NGOs and associations in Cambodia, and they are conducting their activities in Cambodia. This is so much in comparison to other countries in the world. Cambodia is a small country, but we have so much NGOs in Cambodia. Another issue question from Mr. Benaso. In regard to a lot of killings, no investigations. In regard to human rights situations, I want to inform you that those kill Hazakon female comes apart disappearance and other deaths. Cambodian authorities never ignored them. Concretely speaking, Mr. Kamsapat, who was disappeared, not only you friends of him or NGOs or OHCHR in Cambodia that are concerned about him. But even if the father of comes apart, he lodged a complaint and is waiting the answer for a long time. And we continue to investigate the case from the place of incident of disappearance. We have to seek the components of the offense in line with the law in Cambodia. That we cannot do anything that has loopholes, as you know, Excellency, ladies and gentlemen. Mr. Chairperson, that in Cambodia said yesterday that there are so many cases in Cambodia after the war. After 7 January 1979, after 1993, there were many offenses existed and complicated, and it's hard to find the information and the perpetrators and the conspiracy and evidences in order to compile documents. In the case of Mr. Sapat, there are not only one person, hundred and thousand of cases. Any case existed, we have to find enough evidence so that we avoid any wrong arrest or something like that. And I make a lot of visits to some country, for example, in Denmark. They said that only 25 offenses in their country, but in Cambodia, hundreds of thousands of after the war, offenses that we are working tirelessly to tackle. That we have to answer appropriately to the family of the person who disappeared, and also to the OHCHR. Besides this, not only investigate the disappeared people or the journalists who die, as you mentioned that 12 journalists have passed away. According to our investigation, we found 3 cases. We compiled the documents and sent them to the court for trial. And we continue to find the ways to tackle the issues of their property damage. There's a committee to investigate this with heading by Deputy Prime Minister and members of the committee in order to work on this. It doesn't mean that in Cambodia there is impunity, continue to have impunity. It's not like that. I want to assure you. This is the first issue. The second issue in relation to prison system. Mr. Masmat already mentioned in regard to integrity or lack of I want to inform you that I work with the Ministry of Interior with the prison system. I work with them almost every day basis. There are some accused people, they already have diseases, and then we put them in the prison, and then his condition got worse, and that we took into consideration, and then we have to take him out and at the hospital, and some accused they provoke that they have disease, they have also infection disease, so that they can get out of the prison and go to the hospital as well. So I want to inform you this kind of things that happen in the prison. And some of the prisoners, the number of prisoners in Cambodia, number of prisoners. If you look at the report, more than 10,000 prisoners, and the accused person and prisoners, more than 10,000. We separate them because we have 24 prisons in each province. We have 24 prison. The smallest smallest province is Cambodia province. There is no prison. So 24 prisons, as mentioned by Mr. Matsamat, we arrange them in category levels and by age and by sex, in order to keep them living in a proper condition. And we also have the law on juvenile justice system to separate children who live with their mother and so on. That's all. Thank you.
Thank you, Excellency. Let's, without further ado, move on to the second round of lists of issues. And if there are other questions from colleagues, they can be raised. But let me start by asking you to cooperate with the chair when it comes to the use of time. We need to keep our questions focused. And I'd also invite the delegation equally to cooperate when it comes to use of time. General statements simply use up time for the specific questions that we need to put, and that hampers the dialogue. So without further ado, I'd like... Mr. Wasawa, you have the floor.
Thank you.
It's automatically. It's automatic turn off. No. It's automatic turn off. Oh. Yeah, I don't know why. You have to translate it in Cambodian. Oh. Okay.
Hello.
Some awkward. I don't know.
Our dialogue. Okay.
Disculpe, señor Iwasawa.
I do apologize, Mr. Wasawa. There seems to be a problem with the English. Is there a problem with the English?
I'm speaking in English. Okay? Okay.
La interpretación.
Yes, I meant interpreting back into Cambodian, presumably.
Chairperson, first of all, I'd like to thank the distinguished delegation for giving responses to our questions in the first round of our dialogue. We are having a dialogue. This morning, for the second round, I'd like to ask questions on issues numbers 15 and 28. So I start with issue number 15 on the extraordinary chambers in the courts of Cambodia. And I thank Her Excellency Ambassador Ney for giving his views on the ECCC just a while ago. And I thank the government of Cambodia for giving information on various areas where it has cooperated with the ECCC, including physical infrastructure at the court premises, medical services for accused persons, and the security-related matters. According to information before us, however, in 2013, the government refused to pay remuneration to Cambodian staff. Could the distinguished delegation confirm that the government of Cambodia will comply with its obligations under Article 15 of the agreement between the United Nations and Cambodia? Now, the written replies to the list of issues state in paragraph 22 that, and I quote, the Office of the Court Investigating Judges independently investigated and continues its investigation into case files 003/004 without any interference. It's a positive and welcome statement. However, we have a number of allegations that the government of Cambodia is interfering with the functioning and independence of the ECCC. According to information before us, Prime Minister and some ministers are reported to have made public statements to the effect that cases beyond 002 should not proceed. For example, in February this year, less than a month ago, Prime Minister once again made a statement suggesting and warning that continuation of investigation into additional cases would result in war and chaos. In addition, the following developments raise concern about the effective functioning of the ECCC. The appointment by the UN of a Swiss national as the International Court Investigating Judge was rejected by the Cambodian Supreme Council of Magistracy. And it has been alleged that his appointment was rejected because he was positive in investigation into cases 003 and 004. On 3rd of March this year, just 2 weeks ago, with regard to case 003, the International Court Investigating Judge alone, without cooperation from his national counterpart, the National Court Investigating Judge, charged Ms. Moot in absentia. And on the same day, with regard to case 004, the International Court Investigating Judge, again, alone, without cooperation from its national counterpart, charged in Chayam, in absentia. I repeat once again the statement you made in your written replies, and I quote once again, the Office of the Court Investigating Judges independently investigated and continues its investigation into case files 003/004 without any interference. And I recall that the statement given by the distinguished head of delegation yesterday stated the following in writing. The head of the delegation didn't have time to read it, but the text of the statement I received state the following, and I quote, the RGC respects the legal procedures and the independence of ECCC. ECCC judges work independently and neutrally without receiving any outside advice. The RGC always respects the principle of independence and neutrality of the court. These statements are very encouraging and most welcome. I'd like to ask a distinguished delegation to explain to the committee how the government of Cambodia intends to put into practice and make sure that the ECCC will perform its functions independently without any interference. I now turn to issue number 28 on indigenous peoples. Cambodia has good laws on the registration of land of indigenous peoples. The 2001 land law protects the right of indigenous peoples to collective land title. In 2009, the government issued the sub-decree number 83, which details the procedure for the communal land titling. Moreover, the interministerial circular of 2011 bans further issuance of concessions on the land of certain indigenous peoples as an interim protection measure. However, it has been put to us, the government does not implement these laws appropriately, and that concessions still continue to be granted. According to information before us, the interministerial circular only protects indigenous peoples which have already requested communal land titling. But the procedure is too complex, expensive, and time-consuming for them to follow. They often lack the ability to make a request by themselves. Moreover, even indigenous communities which have already acquired communal land titles experience encroachment and illegal logging on their land. It is reported that, as a whole, communal land titling has been deprioritized compared with private land titling for individuals. Could the distinguished delegation comment on these reports and allegations? In addition, I would like to ask the following question. I thank the government of Cambodia for giving information on consultation with indigenous peoples during the land restoration process. Could the distinguished delegation explain how the government is ensuring the opportunity of consultation with them prior to or on the issuance of the concession? How does the government plan to ensure that opportunity when the interim measures are lifted in the future? Thank you very much, Mr. Chairperson.
Thank you very much, Mr. Iwasaba. Now I turn the floor to Ms. Cyberfor. Ms. Cyberfor, you have the floor, madam.
Thank you, Mr. Chair. I will address today issues number 16, 17, 18, 26, and 27, and therefore I would like to ask you for your indulgence, because they are related to very important rights under the Covenant, namely the right to a fair trial and judicial independence, to participation in public affairs, and stateless persons. With respect to issue number 16, I appreciate the frank answers provided to us by the state parties that there are not enough lawyers in the country, particularly in remote provinces. But on the other hand, the answer also appears to suggest that this is a problem for the Bar Association to resolve. I would like to recall that Article 14 of our covenant provides that everyone charged with a criminal offense has the right to have legal assistance assigned to him or her. Therefore, I would like to know what the steps have been taken by the state party to ensure the enjoyment of this right. How does the state party intend to increase the number of lawyers? Furthermore, I would like to inquire about the reasons for the 24 hours rule pursuant to Article 98 of the Criminal Procedure Code. It provides that only 24 hours after an arrest, a detainee may request to talk with a lawyer. Access to a lawyer is commonly considered as an essential guarantee to prevent that accused persons are coerced into incriminating themselves, which would be in violation of Article 14. So I would like to seek some clarification on this. In addition, I would like to know what are the mechanisms in place to ensure that detainees are informed of their rights upon arrest and that the rights protected under Article 14 of the Covenant are guaranteed in practice, not only in law. With respect to judicial independence, I would like to inquire about the 3 laws of July 2014 that they have been referred to by the distinguished delegations yesterday repeatedly. I'm talking about the law on the organization of the courts, the law on the organization and function of the Supreme Council of the Magistracy, and the law on the status of judges and prosecutors. To what extent were these laws subject to public debate prior to their adoption? Were these drafts also accessible for civil society? When we talk about judicial independence, it's very important to protect judges from interference with their status. For this matter, the Supreme Council of the Magistracy plays an important role because it decides on the appointment of judges, transfers, discipline, and removal from office. Therefore, I would like to know more about the composition of this body. Is it right that the Minister of Justice is automatically a member of the Supreme Council of the Magistracy and that he has the right to appoint other members of the Council? Is it right that the Promotion and Career Progress Commission, established by Article 33 of the law on the status of judges and prosecutors, comprises as its chairman the Secretary of State of the Ministry of Justice? What is the role of the ministry in the allocation of the judicial budget? Is it adequate? Moreover, I would like to ask, what are the measures in place to fight corruption in the judiciary? What are the mechanisms in place to protect the judiciary against political interference and against abusing judges as a tool against political opposition? As I said before, the security of tenure is an important aspect of judicial independence. Therefore, I would like to inquire about the grounds for the removal of judges. The delegation referred yesterday to the removal of judges in cases in which they do not, and I heard, perform well in accordance with the laws. Does this mean that judges can be sanctioned on the basis of the content of their judgments? Furthermore, I would appreciate if the distinguished delegation could explain on what legal basis and on what grounds the president of the Phnom Penh court was dismissed in February 2015 and describe the procedure for such dismissal. Was the Supreme Council of the Magistracy involved in the removal? Are disciplinary measures subject to judicial review? More generally, I would like to know what are the measures in place to prevent political interference? To what extent does the government voice criticism of judicial decisions? I turn now to issue number 18 and the protection against self-incrimination under Article 14, and I've already referred to this right previously. My questions are as follows. How frequently do confessions provide the basis for criminal convictions? Does a confession relieve investigating authorities from investigations? What are the steps taken to prevent confessions obtained by force? I'm concerned about the written response by the state party, according to which confessions obtained under coercion or torture cannot be ruled out without evidence, and that judges use such confessions until evidence is determined in a court proceeding. I would like to ask the distinguished delegation to provide us with a number of prosecutions against officials who are accused of extracting confessions. Is it right that there are financial incentives for police officers for convictions? I turn now to issue number 26. In regard of the election, I have taken note of the written replies which refer to the amendment of Article 76 of the Constitution and the new chapters 15 in the Constitution. We have also heard yesterday from the head of the delegation about the importance of this political compromise. But we are lacking detailed information from the state party about the concrete changes. Also, I would like to know to what extent the changes were subject to public debate. Was there any genuine consultation with civil society before this political compromise was reached? I have a question also on the precise content of the reform. First of all, with respect to the National Election Committee. I would like to know how the National Election Committee will be composed. Will the composition ensure the independence of the committee? I would like to point out here that bipartisanship is not the same as independence, which is an essential guarantee for the right to vote protected under Article 25 of the Covenant. This also requires institutional and financial independence. After all, the National Election Committee is the body that is entrusted with the monitoring of the election. It is not a political body. My second question is as follows. What steps have been taken to address alleged irregularities in the 2013 elections so that they can be avoided in the future? I would like to recall that the freedom of expression is an essential element of the right to vote and to be elected, and that no one should be prevented from speaking out on political issues in election campaigns and before. For this reason, I would like to know whether the amendments to the law on the election of members of the National Assembly provide for any fines for insults against political parties. How does the distinguished delegation explain this on the basis of the freedom of expression and Article 25 of the Covenant? There's information by observers that there were persons whose names were not recorded on the voter list. Persons who believed to have been registered to vote in the elections of 2013 were reportedly not registered in the elections. There are also reports about duplicates, names on the list which could not be identified, and persons who had died or who had relocated from an election district. Has this been subject to an independent investigation, these allegations? How will the new law ensure equal media access and prevent unequal use of state resources? What is the mechanism to investigate complaints about irregularities in the future? Will there be measures in place to enable the National Election Committee to actually recount the votes in the polling stations? Finally, with respect to issue number 26, I would like to inquire about the implementation of immunity of members of the National Assembly. Is it right that opposition parliamentarians were arrested and charged in 2014? On what grounds and on the basis of which procedures? I turn now to my last question, which concerns issue number 27. I thank the State Party for its written replies, which set out the legal framework for nationality. My question is about the implementation of this framework. According to information provided to us, there are many Khmer Krom and ethnic Vietnamese who have migrated to Cambodia several decades ago who are stateless or lack the necessary documentation to prove their Khmer citizenship. This has an effect on their access to employment, education, land rights, and welfare. I I understand that according to Cambodian law, Khmer Krom are entitled to receive Khmer citizenship. The obstacle appears to be the lack of legal documentation necessary to obtain identity cards. The process for Khmer Krom to document their citizenship appears to be difficult. There's information according to which they are treated as Vietnamese because of their Vietnamese birthplace. So I would like to know what are the steps taken by the state party to overcome this obstacle. Please explain the procedure processing Khmer Krom ID applications. Does this also apply to ethnic Vietnamese who migrated to Cambodia? I'm not sure about the law on nationality. Doesn't the 1996 law on nationality provide that any child born to a foreign mother or father who were born and living legally in Cambodia shall obtain Khmer citizenship? What steps have been taken to inform ethnic Vietnamese about this application process? What has been done to overcome the uncertainty with local authorities? This brings me to the end of my questions. I hope that this time it was much more precise that we are asking questions, because I understand that the delegation had unfortunately misunderstood that we were making comments. The purpose of this dialogue is not to make comments, and I was somewhat struck by listening to one member of the delegation referring to a general comment that we had adopted. We haven't adopted any kind of general comment. We are engaging in a dialogue with the state party, and we very much look forward to receiving answers to these questions. Thank you very much.
Thank you so much. Now I turn the floor to Ms. Waterwell. Ms. Waterwell, you have the floor, madam.
Thank you, Mr. Chair. Let me first thank the delegation for the replies on the questions I have asked. I will now ask questions on issues number 19, 20, and 21, and that's on the freedom of expression and association and the right to peaceful assembly. We take note that freedom of expression, press, publication, and assembly is guaranteed by the Constitution of the Kingdom of Cambodia. And we also know that this freedom is not without some limitations. There is concern that several pieces of legislation within the revised criminal code exist in Cambodia to unnecessarily limit freedom of expression, peaceful assembly, and association, and these are defamation, disinformation, and incitement. In paragraph 37 of your replies to the list of issues, you stated that the inclusion in the criminal code is to prevent anarchy and to protect the rights and honors of individuals. But there is concern that these limitations are used to harass human rights defenders as well as journalists. And you haven't replied to the question on how many criminal proceedings were brought against human rights defenders and journalists for defamation, disinformation, and incitement. But we have some cases, information on some of the cases. In January 2011, human rights worker Sam Chang-ki was found guilty of defamation. In February 2014, Duang Solida, also on defamation, found guilty on defamation for opinion on social media. In September 2010, Sam Rainsy for disinformation. In December 2010, Seng Kunakar for criminal incitement. Another concern is that journalists are threatened to be prosecuted under the penal code, which is harsher, rather than the press law for defamation, public insult, and incitement. Will you please comment on these allegations? You have not provided us with data on criminal proceedings against human rights defenders, nor has the NGOs, because, as they have put it, they have no access to any public information concerning the number of criminal proceedings during the period under review. In this regard, we want to ask you to provide us with some data on this issue. We also want you to consider decriminalizing the offenses which unnecessarily restrict the above-mentioned freedoms. Limitations on the freedom of expression has to be in compliance with Article 19 of the Covenant. And we want you to keep this in mind while drafting the cybercrime law. Will you please elaborate more on regulations governing the use of freedom parks and roadblocks to prevent access to the freedom park? Can you also give us information on the legal status of the municipal security guards and their role in the demonstrations? What is your comment on reports that there is a practice of detaining peaceful demonstrators until they sign or thumbprint a document agreeing to refrain from participating in future demonstration? And my last question is, can you indicate when the draft law on association, NGOs, and trade unions will be submitted to the National Assembly? And with this, I will also thank the delegation for their answer. Thank you, Mr. President.
Thank you very much. El próximo orador en...
The next speaker on my list is Mr. Rodriguez-Recia. You have the floor, sir. Thank you very much, Chair. I'm going to apply the parameters that you specified to be more specific. So I'm going to refer to issue 22 and 23. Now, this deals with the issue of gender. And this has to do with legislation number 950 of the Civil Code, which establishes that a woman who divorces or has her marriage annulled can not get married again until 120 days after the dissolution or annulment of her previous marriage. So it's not a new issue. The CEDAW committee has addressed this, as has the Human Rights Committee. So where's the problem? Well, the state justifies this restriction on the remarriage of a divorced woman in the fact that the right of the child to be born with paternity needs to be safeguarded. It's to recognize that paternity, and that's to the detriment of the freedom of the woman to take a decision about her own private life, about her own marriage. And so, in my view, there's an unnecessary invasion here in terms of the freedom of the woman to decide on her own life, especially with regard to the paternity of her children. So it's nothing new, but Article 950 of the Civil Code is derived from Article 733 of the Civil Code of Japan, and this committee is concerned by this, especially with the review of Japan last year. This was also discussed. And so the concrete question here to the state is if it would be possible for the state to discuss about the possibility of amending or reforming or in some way not applying Article 950 of the Civil Code. so that there be no discrimination against women, especially divorced women in this case, and so that this 120-day limit is not applied. But another issue that I also wanted to cover that has to do with discrimination against women in Cambodia is the MOFAS guidelines that establishes restrictions on marriage between foreign men and Cambodian women. Now, this is a law of March of 2011. Now, according to this law, a foreign man who is over 50 years of age, for example, me, I wouldn't be able to get married to a Cambodian woman just because of my age, but also because of an economic or financial restriction. Now, that means that that foreign man who wants to marry a Cambodian woman has to earn more than $1,500 per month. Now, these restrictions, from the point of view of the covenant and the whole issue of discrimination and the right to freedom, well, in this committee, we believe that these restrictions should be modified, amended, or revised. And so I'm wondering whether it would be possible to open up a discussion on this issue and to eliminate any kind of discrimination here. Now, I do understand the spirit. I do really understand it. And the concerns that you have in order to avoid any kind of risk with regard to trafficking, human trafficking, or indeed violence against women. But the presumption that foreign men and the restriction that's there in terms of age and financial restrictions and that they can't get married to a Cambodian woman, well, I think that that's an exaggeration. It goes too far. Now, finally, with regard to issue 23, I think that we have already discussed to some extent the establishment of a juvenile justice system, but I'd like to specify the following. We don't know whether there are specific laws to improve this system. We don't know whether there's the existence of a specific reform that will allow us to clearly separate the criminal justice system, that's the ordinary one, from the youth criminal justice system. Now, we also are aware of the efforts ongoing for a draft law that seeks to create some sort of system, but that's been ongoing for 14 years. So I'd like to have more information about that, if I could, please. I'd like to know whether there's any possibility for this draft legislation being implemented soon. That's my question. Thank you.
Muchas gracias.
Thank you very much, Mr. Rodriguez. Now I'd like to give the floor to Mr. Iyad Ben-Ashur. Mr. Ben-Ashur, you have the floor. Thank you very much, Chairman. I'm going to deal with issues 24 and 25 together. Now, this has to do with the protection of children, so hopefully that'll be quicker. And the questions which are being asked here are about what measures are being taken to eliminate child labour. And secondly, to eliminate corporal punishment and other forms of punishment, no matter what form they may take. And the question has to do with birth registering. So I'm going to deal with those together to save time. So first of all, I'd like to note that Cambodian legislation, and I'm going to be quite specific here with regard to the constitution that contains a very clear article, that's Article 48 of the Constitution in Cambodia, which protects the rights of children. Now, the state assures the protection of the rights of the child as they are inscribed within the Convention. And I think here we're talking about the Convention on the Rights of the Child, especially the right to life, the right to education, the right to protection in times of war. and the protection against economic exploitation and sexual exploitation. The state protects the child against any action which would damage their opportunities with regard to education, access to health, or indeed well-being. So that's as far as the Constitution is concerned. I also see, in looking at the dossier that we have before us, that Cambodian legislation is concerned with the protection of the rights of the child. And there is a minimum age that is imposed for labour, and that's 15 years of age. And for work between 12 and 15 years of age, legislation strictly regulates child labour. And I can also see that there has been a decree, and that's 1258 of the 7th of March 2009, in which Article 113 prohibits any physical or moral punishment in establishments. So that's protection of the child at school. Against any physical or corporal punishment.
Et je vais m'arrêter là sur la législation parce
I'll leave it at that on the legislation, because it seems to me that, generally speaking, the legislation exists and indeed protects children. But there again, we seem to have a problem with the actual implementation of legislation in Cambodia, which in theory protects children. According to the statistics, 10% of children between 5 to 17 years of age work. And I also see, and this is in the light of a survey that has been carried out by the ILO together with your government, 5% of these children are engaged in dangerous or hazardous work. Then we have the use of children or their employment in the informal sector. Despite the control and the oversight that you try to conduct as regards children working, there is a large percentage that seems to be escaping any form of regulation and control in the informal sector. As regards registration of births, there again, I do acknowledge the fact that your government is making an effort. You have some decree, I think you call it a sub-decree, literally according to the Cambodian terminology, regarding registration. This is 103 of the year 2000, which obliges all families to register the birth of their children. So there is this obligation. And I believe that the effect of this legal text has now been felt over the last few years for the better. Again, on birth registration, there seems to be a huge disparity depending on the regions. Phnom Penh, of course, is better off in this regard because, of course, it's, I'm sure, the city which has best administration in Cambodia, but you have other cities where registration levels don't even reach 80%, as they do in Phnom Penh. So in practical terms, there are some problems. And my final question, it's not so much in terms of the practicality, but the law itself. This is Article 45 rather, of the Civil Code, which authorizes parents, allows them to use corporal punishment, physical punishment, and that is not deemed to be violence perpetrated against children. And with that in mind, I'd like to know whether the government intends to change this article 1045. In the concluding observations, the Committee on the Rights of the Child recommended that Cambodia should review this article 1045 of the Civil Code in order to improve the protection of children. So, Chair, those basically are my main comments on these two issues. To summarize, the state of legislation, first of all, in line with the Constitution, it does seem to be making progress. I think we can acknowledge that, but there are practical problems still pending. And then we have this legal problem of 1045 of your Civil Code. And the Committee on the Rights of the Child has asked your country to revise that. The Chair. Thank you, Mr. Benachot. I'd like to give the floor to Mr. Fourville. You have the floor, Mr. Fourville. Thank you, Chairman. First of all, allow me to welcome the delegation from Cambodia and thank them for the many answers they have provided so far. I wanted to pick up on some of the questions that have already been raised. First of all, on the incrimination, the criminalization of genocide under Cambodian law. You know that the definition of genocide under international law is limited as regards the groups targeted. When it comes to case 002 that was brought to the extraordinary courts or chambers, the crime of genocide was only related to certain acts committed against minorities in Cambodia during the Khmer Rouge regime. And this, I think, caused a degree of, well, disappointment, really, and astonishment. I believe that when we talk about genocide in Cambodia, we are talking about all the massacres that were perpetrated by the Khmer Rouge regime. And then there is the non-retroactivity of the criminal law, which was to correct the problem. So the question I want to put to you on this is that, is this going to encourage your government to consider changing your definition of genocide in your national legislation in Cambodia for those crimes perpetrated, of course, in the future, not only in Cambodia, but in other countries? And a supplementary question. The crime of genocide or other crimes, are they covered by universal competence, so the Cambodian courts can establish their competence for this in other countries? An additional question, again, has to do with international crimes and punishment of international crimes. But again, talking about genocide in Cambodia again, it's true that the extraordinary chambers are not going to be able to judge all the perpetrators, everybody responsible. I'd like to know whether you're anticipating complementary measures as a state party with a view to either judging other perpetrators or others who are to be held responsible, or taking other measures that will allow you to establish the truth and justice to ensure that the right to truth and justice for victims of genocide is in fact respected. The Chair, thank you.
Yes, Miss Cleveland. Miss Cleveland, you have the floor, madam.
Thank you. I would also like to welcome the distinguished delegation and thank you for your engagement with the committee. I wanted to raise two issues, the first of which falls on my colleague Ms. Watervall's questions regarding freedom of expression, association, and assembly. I wanted to join her in commending you for generally recognizing and respecting openness of communication on the internet and freedom of activity by NGOs, particularly in relation to other countries in your region. The committee welcomes this. But I wanted to raise questions about two pieces of pending legislation that we have been informed about. The first is the draft law on associations and NGOs, which we are advised contains mandatory and complex registration requirements for civil society organizations, excessive restrictions on foreign NGOs, and vague language that could allow arbitrary denial or application of NGO registration requirements. And the second is the cybercrime law, which we understand is not publicly available, but which may also include excessive restrictions on freedom of communication and privacy on the internet. I'm interested in knowing what the status is of these laws, whether if the government is planning to proceed with these aspects of these laws, what is your plan for ensuring transparent and public, meaningful consultation with civil society organizations to ensure that your government does not adopt any legislation that is inconsistent with international standards? And then more generally, I would like to raise a concern about the prospect of having legislation adopted which is either entirely secret or largely secret before it takes effect as law. This raises general concerns regarding the right of the public to participate in political life under Article 25, as well as the right to information under Article 19. And more broadly, it undermines the legitimacy of your own laws and the quality of your laws and public confidence in the lawmaking process. Then finally, with respect to independence of the judiciary, I would just like to underscore our chairperson's observation yesterday that in light of concerns regarding independence of the judiciary, we would urge you to ratify the optional protocol to the covenant to adopt the individual communications procedure before this committee. Thank you.
Thank you very much. No había visto que un colega más había pedido.
I do apologize, Sir Nigel. You asked for the floor. You have the floor.
Thank you very much, sir. And it was good that I came after Ms. Cleveland, since she raised one of the two issues I wanted to raise, namely the question of transparency in the adoption of legislation. I'm grateful to the delegation, and I should add my voice of welcome to the delegation, since this is the only time I'm intervening. Grateful to the delegation for drawing to our attention paragraph 230 of the report. There seems to be a statement in there that we'd overlooked, namely that prisoners are apparently denied the right to vote. And my question is that a blanket denial? Because if it is, then there are problems of reconciling that with the covenant, with the internationally agreed principle that imprisonment should not involve further restriction of rights than those necessarily involved by virtue of imprisonment. That under Article 10 of our covenant, the main purpose in detaining people, in imprisoning people, is their rehabilitation, and of course denial automatically for all prisoners under all circumstances of the right to vote is hardly reconcilable with that principle. So we'd be interested to know, one, if it is a blanket rule that prisoners may not vote, and if so, what thought has been given to the existence of the rule in the first place and the continuance of the rule in the second place. Thank you very much, sir.
Thank you very much. Bien, no tenemos más.
No more questions. It's 11:45. We have to give a little bit of time, of course, to the delegation to prepare their answers. So let's suspend the meeting until midday on the dot. At 12, we have to continue because I do want to be able to conclude the dialogue. So thank you for your cooperation. And so we resume at midday.
Muchas gracias.
Thank you very much. Once again,
Thank
welcome back. We are examining the review of Cambodia, so not to lose any time, I'm going to give the floor straight away to the distinguished delegation. We're going to try to concentrate the replies within a period of no more than 45 minutes so that there's time for follow-up questions afterwards. So, without further ado, I'd like to give the floor straight away to the distinguished delegation. Thank you.
Cambodian delegation, on behalf, I would like to give the floor to Excellency Nazim Ol, Ambassador to United Nations in here, in regard to ECCC. Please, Excellency.
It's the same problem in English. Yes. En la cabina.
In the booth, which is interpreting English into Cambodian, could you please check to make sure that's working, please, with the conference services?
Could you speak?
Yes. Okay. Thank you.
Thank you
okay,
so much.
it worked now. Okay. I wish to respond to the question raised regarding to the ECCC. The question posed that in 2013, the government refused to pay the remuneration to the we call national component staff. This is not really go in the way like that. It's not refused, but there is some delay in terms of contribution of the government part to this code. But at the end, we pay. We contribute according to the agreement on the establishment of the code. And the delaying problem is not happen for the Cambodian government, but also happen from the international component of the code. So the government always honors what it mentioned in the agreement. So we commit to what we agree on in the agreement. And regarding the second point of the case 002 relating to the genocide crime or crime of genocide, it is the discretion power of the court, of the judge. The government have no role to play whether the case 002 or the court will make decision of which crime should be put on the accused in this court. So we have no role to play at all. We have no interference in this court. And for the case 003, 004, of course, the co-investigating judge pursues that case without the cooperation, or I may say, frankly, without the consent or approval from his counterpart, from their counterpart. But we have a clause mentioned clearly in the agreement of the court that, for example, the co-investigating judge disagree whether to pursue the case to 003, 004, or 005. So we have a clause to deal with it. I will not go into detail how to solve the disagreement between the co-investigating judge, national and international. But if you have time, you check with the statement or interviews by Mr. Law Osland. He's the spokesperson of the court. He mentioned clearly how to solve that differences. So, and relating to the accusation that our Prime Minister interfere in the court proceeding or the court case, we have no interference in the court, but we have to think as well in terms of peace, stability, national reconciliation. We have to think about it. Cambodia suffer a lot because of the past, the crime in the past. And then finally we find peace. So we have to maintain peace. Of course, we have to think also, we have to be responsible and have to respect the international instrument, but also we have to think about the peace, about stability and economic development of Cambodia. So the rest part, I pass the floor to delegate. Thank you.
I would like to give the floor to Excellency Edredi, Vice Chair and representative of the Ministry of Justice in relation to point number 16, number 18, number 22, 22, 24, 25, 16, 18 in relation to lawyers and the creation, corruption in judicial system and the dismiss of the president of the municipality court and marriage women and so on. Please, I give the floor to Excellency Mr. Edredi. Thank you. I would like to pay my respect to Mr. Chairperson and members of the meeting. Follow the review of this report. Thank you. Because of the time frame, I would like to start in relation to lawyers. As a matter of fact, we recognize that in Cambodia, at the present time, we have about 500 lawyers only that are working in Cambodia, but in the provinces, in faraway provinces, we meet some difficulties in finding lawyers because lawyers is private individuals, private organization. They work for profits. They charge the fees from the people who need lawyer services. So in faraway provinces, there are difficulties in finding the fees. That's why they don't move to the provinces. That's why it's sometimes difficult in the provinces to find lawyers. For example, in our law, we determine that those who are involved in criminal offenses, perpetrators, criminals, and juvenile, they must have lawyers. So, in order to get the lawyers, how states would take care of the problems. When juveniles and criminals, adult criminals, when they have a possibility to get lawyers for themselves, the state is responsible. The state has the obligation. It means that the court decide the lawyers for them without paying any fees. Paying fees is the obligation of the state in that case. But this case, we recognize that there are some delays because juveniles or criminals that they cannot find lawyers themselves, the court has to request the lawyers from the Bar Association of Cambodia. And the Bar Association of Cambodia, they send them from the province to defend. Through Ministry of Justice, the government subsidize some fees, to those lawyers, so that they can travel to defend the cases in faraway provinces, or those who have no possibilities for those who cannot find the lawyers themselves. At the same time, in the our law, 24 hours after detaining, then the interviewees can meet them. This is the issue that we are discussing, whether we should take this point away or eliminate this point. The Ministry of Justice is studying how to amend our law on criminal procedures code. The Ministry of Justice is looking into this issue to make amendment. After detaining, there must be a lawyer or something like that in line, according to the law. But if they can allow the lawyers to meet their client immediately, it's nothing wrong. It's nothing against the law. But in Cambodia, there are some difficulties, challenges that we have to make the law like this, because the code of conduct of professionalism is not respected properly. So it affects the investigation of the police. It affects the investigation of the police. That is why when detaining, there must be immediate lawyers to meet them. But because they give the time frame to the police to work on the issue first. This is the issue. But we are studying this issue right now. This second, in relation to the three major laws about the judicial system, whether these laws are consultation widely or something like that. These laws, I want to inform the meeting that the laws was drafted many years, and forums provided to the public, and examine the discussions. It's not the beginning, but finally we prepare the laws final stages because of so many consultation and discussion. They were delayed because many views, people, some view this and some views that, and there is no one agreement or something like that. So it delayed. The law was delayed so long. So the government decides that within 6 months to finish the laws. So for 6 months to finish the three laws, if we give the time more to meeting or workshop and so on, it's impossible to do that. So 6 months they have to finish the laws and so on. This is the issue. For the establishment of the Supreme Magistrate Council, members of the Supreme Magistrate Council, 11 members. We have 11 members. In that, we have 3 members. Members are automatic members. One is Minister of Justice. 2, head of the Supreme Court. third is the general prosecutor in the Supreme Court. And besides this, members appointed by votes. One member appointed by the Senate. Members of the Senate elect one individual those who are former judges or former lawyers or former prosecutors or those who work in the judiciary. So they must have 15 years experience. Another member selected by the National Assembly. They are voted those who have expertise experiences in the legal fields, like former judge, former prosecutor, former legal expert, and so on. The third, another member selected by the Supreme Magisterial Council. They are former judge or former experts and lawyers and so on. They must have 15 years experience. Fourth, one member appointed, nominated by the Minister of Justice among full-time prosecutors. And another member is selected by votes from the appeal court and Supreme Court. And so appeal court and Supreme Court, they have select one judge to be member of the council. Another member nominated from the representative of prosecutors from the highest, like Supreme Court or general prosecutor of the appeal court. They have to select one representative, the highest prosecutors, to be members of this council. Another member is selected from the lowest court. It means that the court of instance from the municipality and from the provinces, they have to select one representative, a judge to be member of this council. And another member nominated, represented by the prosecutors of the court of instance. It means that prosecutors of the lowest court, like municipal court and district court and so on. So they have to vote a representative to be member of the council. This is the arrangement for components of the Supreme Magistrate Council. After they are nominated through votes and automatic and they have to be submitted to the king for royal signature to appoint them with royal degree from the king. This is the arrangement about the Supreme Magistrate Council. Another issue in relation to the corruption in the judicial system. We know that in Cambodia we have anti-corruption unit. Anti-corruption unit work tirelessly in relation to corruption issues in the judicial system as well. In the past, anti-corruption unit arrested one prosecutor, one judge. They are related with corruption, and they were sentenced to. They were imprisonment by. They were tried and imprisonment. This are the work of the anti-corruption unit of the Kingdom of Cambodia. Other measures at the Supreme Magistrate Council, we have inspector unit to monitor the complaints of the citizens. If the citizen lodge the complaints to the judge or prosecutors that dealing with corruptions, the Supreme Magistrate will monitor, it will inspect that and to collect information and investigation, and send these documents to anti-corruption unit in relation to corruption. This is the measures that we have taken in relation to the dismiss of the president of the municipal court because there were irregularities in dealing with cases, and we could see that there something related with corruption as well. That is why the Supreme Magistrate of Council discussed the issues and decided in line with the regulations to stop to the activities of the president of the municipal to make sure that investigation can take place. If he's not dismissed, and it's hard to investigate because those involved are under his power, and he himself involved in this case. If he is not dismissed from his position, investigation could be very hard. So we have to keep him in one place first so that we can continue to do investigation on him. And relevant people in this case as well are investigated. Another issue in relation to confession by force. In principle, by law in the Cambodia system, they don't accept confession by force. By torture, the confession is useless, cannot use in the court. We don't use them. We don't use them as evidence in the court in Cambodia, according to the laws. But the difficult issue is lawyers, what the lawyer says, the accused person as well, never show any concrete evidence in regard to torture or confession that are false. They don't show evidence to the court. They only say my answer to the police, I reject that answer because police forced me to answer that like that. How could we believe that? If they just say something like that, there is no evidence to prove. And when it comes to the prosecutor and the judge, his answer is the same. When it comes to the trial, when it comes to the trial time, they say that the confession are forced to answer. So why before the investigating judge and prosecutor, why they have the same answer? Who forced them to accept the same answer with the police in front of the investigating judge and prosecutors? But if there are concrete evidence that they are forced to answer like that by the police, those confessions, the court will reject them. The court will not take them as evidence. Another issue in relation to women, divorce. The law forbid them 120 days not to marry again. This is not a discrimination at all, but it's a protection. It's a protection to the women a protection measure to the child. If within 120 days after divorce, if she's pregnant, and if she allowed to marry again, what happened to the baby? What happened to the baby that is born? The new husband will not accept the baby. So what would happen in this case? This is the issue that Cambodia has taken into consideration. So they keep possibilities beyond the period of 120 days in order to maintain the pregnancy. But in contradiction, if the woman have the forensic, medical forensic or something like that, and with the certificate that she is not pregnant, she can remarry again. The law does not prohibit her from getting married again if there is a certificate from the medical doctor that she is not pregnant. So there must be a certificate from a medical doctor. She is allowed to remarry again. This is a protection measure. It's not a discrimination measure. Cambodian law is not a closed door law. Women who are divorced in relation to 120 days, the meaning is to protect the pregnancy of the woman. Another issue about juvenile justice system. I already informed in writing already. At the moment, Cambodia does not have a separate law. We use general code. But in the criminal codes, we have articles related with the juvenile justice system that we have to use for Cambodian courts. Even though there are not the juvenile justice system, Cambodia does not want the juveniles to be inserted into the general system like that. But we are trying to draft a new law. It's called Law on Juvenile Justice. That law, up to now, we have studied discussions, consultations with CSO, NGOs many times. Every meeting, every discussion, every dialogue, we invite the representatives of representative of the Child Committee, Cambodian Child Committee, and some other NGOs that are involving with the works of children, including United Nations organization, UNICEF. UNICEF also involved in this, so they come help with the drafting of the law of the juvenile justice system. But we are ready to send this draft law to the Council of Ministers, so they will they make adoption. After that, it will be sent to the National Assembly. This is the process of preparing the juvenile justice system in Cambodia. Once the law, then we will establish a system for juveniles. But we meet a lot of challenges in implementation. As you know, that in principle, to create a juvenile justice system, a new developments that have been created in the law, there are two important. One is to divert the juveniles from the court. those who commit offenses, we don't want them to go through the courts. We want to divert them to the rehabilitation outside the court system. This is a new issue for Cambodia. We need a lot of understandings in local authorities and so on, in order to accept the rehabilitation of the juveniles. Second important issue, we create a separate youth rehabilitation centers. If we divert them and we don't receive any results, then they have to go through the court systems and they will be sentenced according to the laws. Those juveniles, they will be put into the rehabilitation centers, not in the prison. So putting them in the rehabilitation centers, we have to create the rehabilitation centers. Again, we must have staff. We have to have managers, and we have to have care people. So these are challenges. We have to need training. We need budget to build the centers, and the difficult issues in Cambodia. Mandalkri province, for example, one juvenile, whether we create one center for only one child or something, one juvenile. This is the issue. 24 provinces, whether we have to create 24 centers or what. These are the challenges that we are studying. We create for example, if we create one center in Phnom Penh and send one from Mandalkri to Phnom Penh because they live far away from their family, if the parents to come to visit, how do they come to visit? What happened to their visit to their child and so on? So even though the law is not adopted yet, we have to consider these issues. How we can approach, how we can build up the juvenile justice system in Cambodia. Another point in relation to the elimination of child labor. In measures in the Ministry of Labor, they have inspection unit, or what called labor inspection unit at the factories, enterprises. This team they monitor whether they have any child labors in that. In the past, ministers of labor in cooperation with ILO to monitor some children, and they are confiscated those children. But I know that when we I myself come here also, when the report on child rights, I also come here as well. Question raised that if we find the child who work in that place or enterprises, or factory or enterprises, we take him out. The question was, how do we prosecute the enterprise owner or factory owner that use child labor? The question was raised like that. But in Cambodia, what happened the parents themselves, the parents of the children, they take their children to work there, to work with them. For example, in soil fields, in brick factory, the parents work there, and the children who live with them, they allow them to work with them to get the salary. How do we arrest the owner of the factory that allowed the children to work? What happened to the parents? The parents that allowed them to work there, whether we arrest the parent as well? That is the issue should be considered. If we arrest the factory owners, the parents, and the children, what happens next? What are the issues will happen next? Who will take care? Who will take care of the children? These are the challenges that everyone should know. These are the problems. Implementation is not something like that we see from the outside. And this is in relation to the elimination of child labor. We have a dissemination program and instruction, guidelines, regulation to prohibit children to the workplace. But Cambodian laws also allow that a child who is 15 years old can work. But there are conditions apply. How they work, what kind of jobs they do, what kind of works they can do. It's not just allow them to work or something like that. This is okay, we are working on this. Another point of issue in relation to torture on children. Legal means civil law, civil code, as well as the domestic law on domestic violence. Allowed parents to use small violence to their children in order to correct them. This is like parents, they want to correct their children. They can use, this is in principle, they are allowed to educate their children or something like that, using minor, very, very minor violence against their children. It's not a domestic violence. In Cambodia, it's the historic ways. We cannot change them overnight. But that's very, very minor behaviors to their children. But if they are serious problem or offenses or domestic violence or injured or something dangerous, the law will not allow them. That's all. That's all. That's all. Because we don't have so much time. So that's all. Thank you very much, His Excellency Edradi. Now, His Excellency Polum, please make a summary in relation to point number 19, 21. Well, 5 minutes for you, sir. Thank you very much, Mr. Chairperson. In relation to ethnic Vietnamese, they are not employed or something like that. In Cambodia, we do our research. Not only Vietnamese, we have about 20 nationalities who live in Cambodia, and this we in relation to this something difficult to get nationality. The process of applying nationality is not that difficult. If those living legally in Cambodia, we use the law on nationality. We have law on nationality. They can apply to get nationality. Number two, those they come to do investment to make investments that they have sufficient investment capital that they can apply for nationality. And another thing is that they can get nationality through marriage, in line with the law of Cambodia. This issue in relation to the registration in subdegree 103/2000. This subdegree assured regarding the laws, because in Cambodia any documents before 1979 they were destroyed by the Khmer Rouge regime. So we make this subdegree in order to make birth registration for children who were recently born. Two, those who have no identities document at all. Those like 20, 30 years old, 50 years old, because they lost all the documents in the Khmer Rouge regime. They have to come to get their birth certificates. Our civil law in this article 103 it will be amended. Some of the issues in line with the article 950 of the civil code in 2007. In relation with the freedom of expression and for demonstration or writing or protest, I already said yesterday that all protests, every kind of protest that affect the national security, social orders, the royal government will temporarily prohibit. So the meeting, please be informed that procedures, there are two procedures. One is prohibition of demonstration. Two, temporary, provisionary prohibition of freedom of expression. So the government of Cambodia think about these issues. And another issue, relation with the laws on NGOs, associations. So no more time, so okay. The draft law has been done, yes. Thank you.
Thank you very much. A few follow-up questions. The delegation, of course, will have an opportunity to complete the replies in writing within the 48 hours following the end of our dialogue. The first speaker, Sir Nigel.
Thank you very much, sir. It's not so much a question, unless I've misunderstood, as a comment, so that when the delegation receives our concluding observations, they're not taken by surprise. If I've understood correctly, because we don't have a proper up-to-date list of who the delegation is, the speaker who was addressing the issue of confessions and people recanting their confessions in court on the grounds of alleged torture and ill treatment. I believe it was the head of the delegation, who also, I believe, is the president of the National Human Rights Committee. So I find it a little bit strange to hear the explanation that the problem is that people just say they've been tortured without offering any proof. As I think Ms. Seibert-4 mentioned when addressing issue number 18, it is in the nature of imprisonment that the people who are imprisoned are not usually in a position to offer proof of anything. The burden is on the prosecution to prove, if challenged, that the information was indeed given freely. And if that is not the case in Cambodia, then clearly it will be necessary for us to make a recommendation that that be the case. It's also slightly troubling to hear that judges don't automatically themselves inquire into what happened when individuals do allege that they have been ill-treated and accordingly may have made a confession under those circumstances. It's up to the prosecution it should be up to the prosecution to prove it, and it should be up to the judge to make sure that they are convinced by it and to look at the allegation, not just dismiss it because the individual hasn't been able to prove it. Thank you, sir.
Muchas gracias, Sir Nigel.
Thank you, Sir Nigel. Mr. Rodriguez Recia, you have the floor for a follow-up.
Muchas gracias.
Thank you, Chairman. I think there were many questions that remained unanswered. I asked many questions that you didn't answer. And let's hope that in the next 48 hours you could answer those questions. I'd like to know whether there's a commitment from the state party, because an awful lot of things still remain to be done. You say that you've got a bill, you've got a bill for criminal justice, etc. But a state, it's fine for the state to say you take note of NGOs and international organizations, but public policies, bills, etc., don't depend on the workshops that you hold with civil society, which is all well and good. But this draft bill, I think, is 14 years old, if I'm not mistaken. It's been pending for those years, and many countries, of course, have had problems ensuring that the CRC is in line with their criminal justice system. And you cannot just sort this out by saying, well, is it just one person who's a minor and we're going to build a rehabilitation center for them? No, we're not talking about this. We're talking about a systemic solution that you need for all these issues, adopting really a comprehensive approach. And that's what you should be focusing on. I'd like to know whether there's a commitment from the state to allow the Office of the High Commissioner and other international bodies, UN bodies, and also civil society bodies to monitor the situation in places of detention and custody. I don't think you answered that question, certainly not the question from Sir Nigel on this, on what does the state think about the fact that people deprived of liberty should have the political right to vote? There seems to be restrictions on that. So how far are you contemplating reanalyzing this? Nor did you refer to this 30 minutes that people in detention have to get fresh air. On corruption, in the police stations, it seems that there is no free lawyer available to them, free legal aid within the 24 hours. You don't note down, or the police don't note down what's happening. And this, of course, leaves the door wide open to corruption. People have to pay cash to ensure that the police accusation is dropped. And this seems to be an endemic problem in your police stations. Please take note of this and how one monitors the record and the register book in the police stations. As regards minors as well, don't tell me that you don't have laser cameras or, I don't know, technology that can be used for those who are minors. And as regards domestic violence and how you combat child labour, it's a culture shift that we need. We know it's an ongoing process, and we know that it's not something that is simply going to be solved with passing of laws. Thank you.
Gracias a usted.
Thank you, Mr. Rodriguez Oresia. I'd now like to hand back to the distinguished delegation to provide us with some answers. As I said, you have 48 hours after this meeting within which you can answer those questions that you weren't able to address now because we are running short of time, or indeed if you feel you need to complement information. And of course, then make your concluding comments. So, Head of Delegation, you have the floor.
Okay, thank you. For our delegation that addressed to the question, but I don't know as well how the answer that you want us to reply to you, whether you need an answer according to your wish. But for us, we already answer to all the questions, like the head of delegation addressed that from question number 15 till, and then we divided into a group of questions. But we did not answer one by one. We answer in general and we combine them together. But I'm doubt whether you pose a question and you expect the answer according to your wishes. This is my general answer. And okay, now I also answer to a particular question regarding paragraph 230. The term prisoner, we mean that is the convicted person. That convicted person have no right to vote according to Cambodian law. And I think Cambodian law is not strange or is not exceptional to the other international law. We uphold the principle of presumption innocent, and we respect fully Article 14 of the Covenant on the Civil and Political Rights. I thank you. And then I pass the floor to the head of delegation to make his concluding remark.
Mr. Chairperson, I thank you very much, and the members of the committee and the meeting. So within these 2 days, we have a lot of discussions and views, questions, answers, and recommendations. This means that we speak honestly together. On behalf of the Cambodian government, we will continue to work hard on these issues. As a commitment of the government, we want a better society as well. Thank you very much for your recommendations, and we will look at your recommendation and work on your recommendation. For the government is appreciates that we cooperate one another for constructive criticism and so on. Thank you very much. The government of Cambodia commit to continue to work on the recommendation in Cambodia and in cooperation with OHCHR in Cambodia and also CSOs in Cambodia. If there is any problems, and we discuss together. For example, if they exaggerated the information, that's not good. We are not far away from one another. We are Khmer, we are Cambodian government is Khmer, NGO is Khmer, and so if anything happen, we can work together, discuss together for success to Cambodia. At the end, I wish, I thank you very much. The committee take times to consider our report and wish you good health and success in all your work and help Cambodia. Thank you.
Thank you, Head of Delegation. I won't attempt to summarize.
Observaciones finales.
You will see those questions reflected in our concluding observations, so I won't attempt to summarize. However, I would like to pick up a couple of points that emerged in the dialogue, and it has to do with the method of our work. When colleagues request supplementary information, they're not asking you a question because of their wishes. No, they're asking you complementary information because it's vital in order to draft our concluding observations. Now, when the state fails to provide us with that information that we request, or certainly doesn't provide more detailed information, and just gives us details, then the state is wasting an opportunity that you have to provide us with information firsthand. I wouldn't assume that the information provided is exaggerated. No, I think states are duty-bound, since you run the public policy, to really take due note of the information that they receive from all quarters. As one of my colleagues said today, this isn't a court where we're judging states. No. We are here to cooperate with you so that the states are able to comply with their international commitments that they've entered into. And when states do come before us, they do this representing their state. So you are representing all state bodies, not just the executive. And I think it's terribly important, therefore, to answer questions that have to do with the judiciary and legislation. And perhaps in the future, in your delegation, you might have some people who come from the judiciary, quite apart from the executive, and that may indeed help promote a dialogue that will be sufficiently constructive. Now, I know the state feels that they have answered all the questions they were expected to answer. Notwithstanding that, I would suggest that within the next 48 hours, you send in all the information that you feel is relevant for us to consider. And naturally, I hope that the committee will see you again soon, and we won't have to wait so many years to have a dialogue. Having said which, I'd like to thank you for being here with us. I wish you a very safe and good journey back home, and we can now adjourn this meeting until the afternoon. I think maybe the Secretary has some comments, something on an informal meeting.
Thank you, Mr. Chairperson. I, in fact, have three very small announcements. One relates to the NGO briefing, which will take place at 2 o'clock in the usual room, RS 181, and it's the NGO briefing on Côte d'Ivoire. So that meeting takes place at 2. The second announcement relates to a slight change in the programme of work. On the 27th of March, instead of methods of work in the morning, you will have communications, and in the afternoon, where you should have had communications, you will have methods of work. I will send that around to the members by email as well, but just so you're aware immediately. And then thirdly, a very important cocktail to welcome new members will take place on the 31st of March at 6 o'clock. So please do mark that in your diaries. That's the 31st of March, just after the session at about 6:15. Okay, thank you very much.
Thank you very much, Ms. Fox. Se levanta la sesión.
Meeting's adjourned.